On Tuesday, the Supreme Court took up two voting rights cases out of Arizona that could shape future election laws in states nationwide. Natalie Brand reports from Washington.
The U.S. Supreme Court heard arguments by teleconference Tuesday on challenges to two Republican-backed voting laws in Arizona. One throws out ballots cast in the wrong precinct. The other restricts who can pick up absentee ballots. Democratic Party officials who raised the case argue the measures unfairly affect communities of color.
Here, what we have is a record that shows that Native Americans and Latinos in Arizona rely disproportionately on ballot collection, and white voters do not.
Arizona's Republican Attorney General Mark Brnovich argues the rules are in place to preserve the integrity of elections, not to prevent people from casting ballots.
Arizona's requirements that ballots be cast at assigned local precincts and its restrictions on ballot harvesting are appropriate election integrity measures that do not create any disparate impact on racial minorities, but serve us all equally well.
The case centers on a crucial remaining provision of the Voting Rights Act of 1965, which prohibits election practices that discriminate on the basis of race.
And it comes as state legislatures around the country debate sweeping changes to voting laws following the 2020 election.
This election was rigged.
And continued unfounded claims of widespread voting fraud. The Brennan Center for Justice says more than 40 states have introduced over 250 bills that would restrict voting access.
This is exactly why we need a strong Voting Rights Act, is to ensure that if any of those policies get passed and they're discriminatory, we have a way to stop them.
The case before the High Court will also test the new conservative majority's approach to voting rights. A decision is expected by the end of June. Natalie Brand, CBS News, Washington.
Caitlin Huey-Burns and Adam Brewster join me now. Caitlin is our CBSN political reporter, and Adam is our CBS News political reporter. He covers special elections and midterms. Welcome. It is good to see you both. Caitlin, let's start with one of these cases, as we saw in Natalie's piece, that has to do with how ballots are collected, specifically a third party delivering someone else's ballot. Now, critics call that practice ballot harvesting, but are there some legitimate reasons that that happens? And if so, what are they?
That's right. Well, the term ballot harvesting was kind of made popular by Donald Trump on the campaign trail and kind of used in a pejorative sense. But what it really refers to is the third-party collection of ballots. Proponents of that say that that helps people with disabilities, helps people in minority communities. In the case of Arizona, they say that that helps people, that helps Native American communities, and that is a critical piece of helping them get their vote to where it needs to go. There are about 26 states that have some kind of practice of third-party ballot collection in place, but critics say that there aren't enough restrictions on it, that not all of these states have restrictions on who can actually collect it for you and how many ballots that person can collect, and they say that that opens it up for fraud. I think it's important to note, though, that cases of fraud in terms of ballot collection are very rare still, but the biggest high-profile case happened in North Carolina a few years ago in that congressional district where a Republican was found guilty of harvesting ballots. And that was in a state that it wasn't even allowed. So you do have people wanting stricter enforcement measures when it comes to that. But defenders of the challenge to the Arizona law say that this is something that disenfranchises minority communities especially, and Native American communities especially in Arizona.
Well, Adam, would eliminating this type of ballot collection potentially impact both parties equally?
Well, we've seen Republicans being the party that tends to be more aggressive in putting restrictions on who is allowed to collect and return ballots on behalf of someone else. That was something that the California Republican Party was pushing a lot before the 2020 election. In Iowa last week, the Republican-controlled legislature passed a bill to put more restrictions on who's allowed to return absentee ballots in that state. That's a bill that's awaiting the signature of the governor potentially. But in terms of some of the things Caitlin talked about, certainly it was Democrats today arguing for a ballot collection process, saying that there are disadvantaged communities who need that sort of help. But more broadly speaking, we saw in the 2020 election, Democratic voters were more likely to vote by mail. Republican voters were more likely to vote in person. So, on its face, it might be a practice that helped Democratic campaigns in the 2020 election. But we just don't know how long that trend and how cemented that trend will be, Elaine, going forward. If, Democrats will continue voting by mail in large numbers once the pandemic is passed, and if Republicans will stick to pushing election day voting, or whether there will be, a sort of swing in that. We've seen both parties take advantage of mail voting at various points in the past couple of decades.
Well, Caitlin, let's turn to the Voting Rights Act. In 2013, the Supreme Court essentially ruled that things had changed for the better since the passage of that landmark act in 1965, that racist policies meant to disenfranchise voters were not really an issue anymore. Yet Chief Justice Roberts also said that Section 2 of the Voting Rights Act was still critical because it bars discriminatory voting procedures. So why then, Caitlin, is the court taking up a case challenging Section 2 a few years later?
That's right. Section 2 is at the heart of this Supreme Court case, and what it does essentially is it prohibits any sort of discrimination based on race. And so when Roberts, back in 2013, was defending his position for gutting part of the Voting Rights Act, he essentially said that the Section 2 remains in place, and that is the key enforcement mechanism. And that's why a lot of voting rights advocates are really concerned about this Supreme Court case that the court heard today, because they believe that if this is thrown out, if the enforcement mechanism left in the law, it doesn't exist, then the Voting Rights Act doesn't exist. But it is important to kind of assess what we heard from the justices today, especially from Roberts. We don't know how he is going to come down on this, but we do know that he is going to, of course, be a key player. And he did have at points challenges to the defenders of the current law, and he also had some challenges for those wanting to challenge the law. So, for example, to the defenders, he made the point at one case to say, why shouldn't election laws seek racial proportionality? That would seem to suggest support of Section 2. On the other hand, he and some of the conservatives on the court argued that a commission established by former President Jimmy Carter and former Secretary of State James Baker established that third-party collection of ballots shouldn't happen. And so, you kind of got some hard questioning on both sides. But this is why it is so important to a lot of people watching this case, is the fate of Section 2 and whether laws that restrict voting can be challenged in the future. We'll have to wait and see where they come down in June.
Yeah, Adam, this is happening as some 40 states try to pass laws that restrict voting, the most recent example being in Georgia, where you and Caitlin spent a lot of time covering this past election. Tell us about the bill passed in the Georgia House last night.
This was a bill, Elaine, that covered a wide variety of election-related measures. Some of the more notable changes that it would make to the election law would be limiting the hours of early voting during the weekend. Initially, this was a bill that got a lot of attention because it didn't allow voting on Sunday, and voting rights activists said that that would disproportionately affect black voters in Georgia. The bill was later amended to potentially allow for Sunday voting, but it is still a smaller number of weekend hours available to people. There are limits on the number and where and absentee ballots can be drop boxed, and the hours that they can be accessed for people returning their ballots. There's also some ID requirements for requesting and returning mail-in ballots using a driver's license or an ID number on your ballot. And it's just one of the bills that we've seen in Georgia, and it covers a wide range of things. In the Georgia Senate, a Senate panel yesterday advanced a bill that would cover some of those similar issues as the House bill. But the big headline in that bill is it would get rid of the state's no-excuse absentee voting system, a system that was put into place by Republicans back in 2005. It remains to be seen how the legislature will square away some of the differences between those bills, what an ultimate bill that got to Governor Kemp's desk would look like. There have been some leaders in the Republican Party in Georgia in the legislature and in state government who have said that they're not sure that they want to get rid of no-excuse absentee voting, but some of those other measures could certainly be on the table. The Republicans control both chambers and the governor's mansion in Georgia.
Yeah, a lot of these debates happening, of course, not just in Georgia, but as we said, all across the country. All right, Caitlin Huey-Burns and Adam Brewster, great to see you both. Thank you.
Thank you.